Well, thank you so much for tuning in to Morning Live. Now, one of the big stories today, suspended South African Revenue Service Commissioner Tom Moyane, he's approached the highest court in the land yesterday in a bid to halt either or both the Nugent Commission and the disciplinary inquiry into his conduct. Now, in his application to the Constitutional Court, Moyane raised a variety of concerns ranging from the two processes running at the same time to the participation of Public Enterprises Minister Pravin Gordhan in this matter. Now, he described the charges leveled against him as baseless and President Cryril Ramaphosa's decision to institute the processes as unlawful. So to discuss this further, we joined now on the line by Eric Mabuza, who is Tom Moyane's lawyer. Mr. Mabuza, thanks so much for speaking to us here on Morning Live.
Good morning, Sakila, and thank you for inviting me to your show.
Mr. Mabuza, your report, the application to the Constitutional Court, it's a detailed application of over 700 pages saying that, in summary, your client hopes that the ConCourt will intervene in this matter. How exactly and why?
You're quite correct that the application itself is quite detailed, and I'm rather surprised that from some of the media comments that I see, it's being reduced to a one-liner that it's ridiculous for my client to claim that it was the best commissioner. But that aside, that people read the application, they would have seen that it's quite a multi-pronged attack and challenge on various decisions that have been taken by, i.e., the President and the Judge Nugent and Azar. So it's not quite correct that, the statements that are made in the application have no basis. Anyone who wants to challenge the allegations that are made in the application must provide contradictory statistics to show that Mr. Moyane was not the best commissioner ever. As far as we are concerned, the statistics speak for themselves. Having said that, you will remember that in the application itself, various allegations are made against the conduct of the President. In particular, we say that this application implicates the conduct of the President. One of them is that the President has appointed his personal lawyer to be part of the Sars inquiry. In our view, that constitutes a blatant conflict of interest. So it does not really matter that Mr. Katz has expertise. The fact of the matter is that he is conflicted. And in our view, that constitutes conduct that is inconsistent with the Constitution on the part of the President.
So if you could help us understand here, what exactly is it that your client is opposed to? Is it the fact that these two inquiries are running concurrently, or is it the fact that he feels he doesn't need to respond to them?
It's the unfairness of having two inquiries running concurrently against him, that he has to attend two inquiries which primarily deal with the same issue. Just to illustrate the point, about on the 7th of September, we received a letter from Judge Nugent where he threatened to recommend for his removal from office. That's quite clear. In fact, that is a demonstration that it is unfair for him to face two inquiries. You ask yourself the question, then what is the point of having a disciplinary inquiry that is being chaired by Advocate Bam SC if Nugent is able to recommend for his removal? That is the clearest demonstration of the unfairness of the process. And we've gone to the President about that previously to indicate to him that that was unfair, but our deaf ears. Hence, we have now approached the Constitutional Court to be the final arbiter on this very, very important issue.
So just on a point of clarity, to bottom line this, your client is not opposed to proving his innocence here, but he would rather have these two processes not run concurrently.
Of course not. If you look at if you go through the affidavit, you will see that he's given a detailed, just a summary of his defenses against the charges that have been brought against him. I mean, one of the things you remember at the beginning of this entire saga was the VAT issue, the alleged VAT issue that he paid to the Gupta. But when you go to the charges, you'll see that there's no such a charge. Somehow that charge has disappeared. And that was the basis of his suspension by the President. All those charges that have been put in place can easily be refuted I mean, for instance, Parliament itself has indicated that it was not misled, but that is one of the charges. When you come to the charge that he paid unauthorized bonuses, we've indicated in the affidavit that he received opinion from three senior counsel. So all those charges, we're able to show that if the process is fair, you'll be able to refute them.
So why does your client not just let the processes then continue so that he can then prove his innocence?
But you can't go to a process which is completely unfair. Take the Nugent process, where we complain about the involvement of the president's personal lawyer. He can't go to that process and legitimize a very illegal process, unlawful process. We even now contend that Judge Nugent himself is biased. I mean, even in the Bama inquiry, one of the complaints that we make against the president is that we are not allowed to lead oral evidence. As a rule, we must first apply to BAM to admit oral evidence. That is the unfairness that we complain of. And the process, if all those obstacles are removed, we will be able to go and demonstrate that the charges that he's facing have no merit, are baseless.
So when you say, for example, that Judge Nugent is biased, can you give us an example of that?
The clearest example of his bias, you look at how the commission unfolded. Judge Nugent has indicated that he met with President Gordhan outside of the inquiry. The next thing that you see is a sequencing of witnesses. The very first witness that is called is Pravin Gordhan after Judge Nugent met with him. He presented a 200-page presentation. If you really wanted to know what is happening at Sars, one would have thought that the very first witness to call would be my client, Mr. Moyane, because he's the current commissioner. You will remember, Sakile, that Mr. Moyane was not even invited to the inquiry.
So does it really matter whether he comes first, last, somewhere during this protest? Does that make any difference whatsoever?
He's not invited. He was not invited.
So
when you look at everything in totality, including the fact that Judge Nugent now says he wants to recommend for his removal, even before the inquiry completes, even before Mr. Moyane testifies, that is the clearest demonstration that there's something wrong with the way the inquiry is being conducted.
I see one of the issues you also raise in your application is around Pravin Gordhan and his involvement, and you've just mentioned another incident here. So why are you so opposed to Pravin Gordhan and him giving testimony, as you pointed out, him meeting with Judge Nugent? Is this personal, or, what is the story around Pravin Gordhan?
It's not personal. You will remember that in any proceedings, a biased witness should not be allowed to testify because their testimony will be biased. But what is surprising, you remember that the hostility between Minister Gordhan and Moyane is legendary, is known. What was surprising is that instead of testifying himself, the president sent Minister Gordhan to depose an affidavit.
So what's wrong with that? Because when you say that Pravin Gordhan is biased, Judge Nugent is biased, everybody then is likely to be biased because obviously they are not on the side of your client in this regard. They're leading testimony against him.
No, that's not the issue. Minister Gordhan is not the Minister of Finance. We would have understood if Ntantanene was the one who deposed to the affidavit. Minister Gordhan has absolutely nothing to do with this matter. If you go through the papers that we filed, you would also see that we detail an exchange between Minister Gordhan and Mr. Moyane, where in fact he shouted at Mr. Moyane and he called him all sorts of derogatory terms, that he is cheeky. I mean, how can it be acceptable that a 65-year-old man is called cheeky and is told to grow up by another man? It's quite demeaning.
Hence, I asked you whether this is personal to a certain degree, and from what you've just told us, evidently it is.
Not from our side. In fact, from Minister Gordhan's side, not from our side at all.
So one of the other issues that I wanted to touch base with you on is, of course, around the withdrawal of charges against Adrian Lakay. Now, there were two sets of charges that he was facing, one brought by Sars and one brought by Tom Moyane in his personal capacity. Now, how much did Mr. Moyane have to do with Sars' withdrawal of that case against Adrian Lakay? And in his personal capacity, why did Mr. Moyane feel the need to withdraw those charges?
Unfortunately, I'm not briefed on that matter, so I won't be of assistance on that aspect. I know nothing about it. It's only what I read in the newspapers. I'm only focused, my brief is to focus on the charges that he's facing in the disciplinary inquiry, as well as before the Nugent inquiry.
So where to from here? Because the Commissioner will resume tomorrow. Several Sars senior managers, they scheduled to give evidence. So what's going to happen now, and what do you expect as a response from the ConCourt that would be in your favor?
Well, we expect the ConCourt now to give directions on how the matter should go forward when the other side is supposed to file their answering affidavit. We've long indicated to the Sars Commission that so long as our complaints remain unaddressed, that inquiry itself is running at a risk. Imagine if the court were to find that, in fact, our complaints have merit. A, Mr. Cass is conflicted. B, the way Nugent is running the commission is improper. It would have been a waste of money. So
and the opposite?
At a risk.
If the converse holds true?
If the converse holds true, then we'd have to subject ourselves to DC.
Well,
ultimately, it's for the benefit of the country that the court must pronounce on this issue. You must remember that the Bill of Rights that everyone signed to, the Constitution, applies irrespective of whether we like the people that are implicated or not. And those rights also apply to Mr. Moyane. So you cannot somehow suspend his rights because people don't like him. He's entitled to those rights and to vindicate them in court, and that is what he's exactly doing now. The country should welcome that finally our final arbiter, the court, will determine whether his complaints have merit or not. I wish people would have that perspective when they criticize us.
Well, we're going to leave it there. Thanks so much for speaking to us this morning, Eric Mabuza, the attorney of the suspended Sars Commissioner Tom Moyane. And quite a bit to happen there, awaiting that constitutional court ruling on the application that was brought by Mabuza on behalf of Tom Moyane. 700 pages of detail there, and they would like the court to halt either or both processes in this regard, and they will be stating their case to the highest court in the land. We're going to take a break, and when we come back, of course, much more to come your way, including the news here on Morning Live.